Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to our Curious Amalgam. I'm Alicia Downey, and the title of today's episode is, Wait, we have to tell who? What you need to know about state premerger notifications. State legislatures around the country have passed or are on track to pass legislation that requires certain transacting parties to submit notice to the state attorney general or other state authority when a transaction results in a material change in ownership. In some ways similar to the federal Hart-Scott-Rodino Act, these material change notice laws typically give the reviewing state agency a fixed period of time to review a transaction before it closes, usually about 30 to 90 days, but up to 180 days in some states. What kinds of transactions trigger these notice requirements? How do they affect transactions involving hospitals and other healthcare entities doing business in a state? And what happens when a transaction is subject to both federal and state premerger notification requirements? Our guest today is someone with the answers to these and other questions about today's topic. But before we talk about all that, I'd like to welcome my co-host, Rubin Waranch. Hi, Rubin.
Hi, Alicia.
Rubin, would you like to introduce our guest and kick off the conversation?
Absolutely. We're joined by Lisl Dunlop, a partner in the New York office of Axinn, Veltrop, and Harkrider. Lisl counsels clients on a wide range of antitrust issues, including transactions that may require submission of a material change notice to one or more states. She is a vice chair of the Healthcare and Pharmaceuticals Committee of the American Bar Association's Antitrust Law section. She also vice chairs the Antitrust Practice Group of the American Health Lawyers Association. Welcome to the podcast, Lisl.
Thanks for having me on. As I say, I'm a long-time listener, first-time caller.
Fantastic. All right. To kick us off, many listeners will be familiar with the Hart-Scott-Rodino Act as the federal antitrust law that requires notice to the federal government of certain mergers and acquisitions. A lot of us, though, are less familiar with these state mini-HSRs that are becoming more frequent. Could you get us started with a baseline of what states are solving for in passing these laws?
Overall, I think these laws show the states prioritizing independent state review of transactions that have an impact on the state, regardless of whether there could be federal review of the transaction. Historically, most of these laws have been aimed at the healthcare space. Healthcare, as you know, is inherently local. There are several state actors that have a role, not only the AGs, but also departments of health and charities bureau that regulate nonprofits. And the concerns there are about cost and access, affordability, but also an interest in ensuring that the residents of the state, and sometimes there are rural areas that are particularly affected by these deals, continue to have access to services. Over time, there have been a lot of concerns with the involvement of PE firms, leading to allegedly increased cost and lower quality. And there have been some high-profile failures of healthcare entities like Steward in Massachusetts and Prospect, which operated in a number of jurisdictions. So it's all of those things leading the states to introduce these laws, particularly as they apply to healthcare deals. But it's not only healthcare deals now. And I think what we've been seeing through 2024 and even this year in particular is a real expansion of the notification laws, recognizing that it's not only healthcare that affects the state's consumers, and also maybe some concerns about not getting access to information that might be available to the federal authorities.
So Alicia previewed it at the outset. Some transactions may be noticed to both the federal government and one or more states. Can you give us some background about how these laws intersect with the HSR Act?
Yeah, I think they intersect in a couple of ways. I mean, first of all, one of the major motivations of these laws is to fill the gap where HSR doesn't apply. Of course, the FTC and DOJ have jurisdiction to look at non-reportable deals, but a lot of deals, and healthcare deals in particular, are not going to meet HSR thresholds. So having these laws kind of fill in that gap beneath the 126.4 million transaction size is a really important thing for the states to get a look at these transactions. The other place where there's interaction with HSR is where a transaction is HSR reportable. And what is the state's role there? And we've seen over the years in all kinds of transactions, states taking an interest in a transaction that's under Hart-Scott review, going alongside the FTC or DOJ through that review, maybe even joining in a challenge to a transaction. But at times, and I think maybe increasingly, we might see a state taking a different approach. There have been fairly rare instances, but some instances where states have actually challenged deals where the federal agencies have not and have allowed the deal to go ahead. And so I think what some of these state notification laws are getting at is they want concurrent notification of a transaction that might be HSR reportable. And there are a couple of ways that they can achieve that, and we'll talk about one a bit later, I expect, which is the Uniform Law Commission proposal. But until that one came along, the states have their own specific notification regimes. And I think that can bring up a really interesting topic, which is potentially being strategic about how you notify a transaction. You know, I do a lot of international deals, and we're always doing, multi-jurisdictional analyses. And do you have to file in Europe? And do you have to file now in the UK and Brazil and China and everywhere else? And working out how you actually stage and manage those notifications, balancing regimes that might just have notice versus suspensory regimes is a really kind of interesting aspect of doing that kind of deal. And those considerations could start to come into play in the US in a deal that is required to be HSR reported as well as reported in various states.
And after a deal is reported to the state, what are the standards that the states use in assessing whether to clear a transaction under its statute? Is it similar to the federal merger guidelines approach? Is it harm to competition plus other considerations?
I think it's the latter. Competition is something that appears in most of these regimes as a really important factor. So that's kind of included, but there are also other criteria. And some kind of public benefit arrangement is often, or public interest factor is often an important factor. And this really sets up the potential for a state perhaps to want a transaction to go ahead, and or the FTC and DOJ to have concerns about a transaction purely from a Section 7 point of view. We've seen these kind of conflicts before in healthcare deals, for example, with COPAs, Certificates of Public Advantage, that allow healthcare organizations to apply to the state for an approval to merge. And they would usually be subject to kind of extensive conditions and ongoing state oversight. The FTC usually opposes COPAs on principle, but also it reviews the underlying transactions and has problems with them on a Section 7 basis. So you can see the way that this is played out in the COPA reviews, the broader set of factors that the state agencies might be bringing to bear as they're considering these deals. And you even saw that in transactions that didn't have COPAs, where the state wanted a deal to go ahead for reasons much broader than competitive impact. And the FTC or DOJ was looking at the deal and kind of raising its eyebrows, but maybe not taking a contrary approach. One example I can think of there was the BI Leahy merger up in Massachusetts in around the 2018, I think it was, where there was a settlement with the AG, and in light of that settlement, the FTC actually issued a closing statement saying that it was a close call, from which we took that they might have actually challenged if there had not been that kind of settlement. when you ask about factors, it really depends on the jurisdiction, right? You've got so many of these laws. I think there are around 34 or 35 states now have some form of notification law, most of them very focused on healthcare. And so you can look at each one and see how they articulate the factors. California is quite interesting, and it's a big one, obviously. They're getting a lot of notifications there. And some of the factors, in addition to the impact on competition, are things like whether the deal would have a negative impact on availability or accessibility of services or the quality of services, whether there'd be a negative impact on costs for payers, purchasers, or consumers. Be part of a series of transactions that trend towards consolidation. That actually has a little bit of a flavor of the 2023 federal merger guidelines. And also assessing factors relating to a healthcare entity's business and relative market positioning. Colorado similarly considers reduction in availability and accessibility of services in the communities served by the hospital. And they deal expressly with transactions involving nonprofits and for-profit entities. So there they bring in a public interest factor, safeguarding the assets which were dedicated to a charitable purpose and ensuring that that charitable purpose is continued even after a for-profit owner.
So, Lisl, taking a step back and from a process perspective, what types of information need to be provided in the actual notice that's submitted to the state?
So that's going to depend on the state. And as I mentioned, there are a lot of different states that have these laws, and each one has its own nuances. So you really need to look at each state's rules separately. Obviously, they're going to have a basic form of information, require the agreements. New York just issued FAQs on its notice law for healthcare transactions and provided guidance on what was needed for the good faith assessment of the impact of the transaction. So they want you to write a narrative that covers what services will be eliminated, reduced, added, or expanded in terms of staffing available or available hours or days of service. They want information on contracts with certain insurance carriers that will be added or eliminated, specifically interested in Medicaid participation. They want to know about locations that will open, close, expand, or reduce service, healthcare staffing changes in particular, payer rate changes, usually whether they're projected to increase, changes in the share of services provided to historically underserved populations, and then the antitrust question, whether you expect any increase in market consolidation as evidenced by changes in market share in any region of the state. So that's just one example of the kind of information that one of these laws is going to require in the notification.
So that's a lot of information. I imagine in some respects, information that will need to be prepared well before a transaction signs. Are companies preparing this information weeks before, or do they typically wait until there's a signed deal to prepare this set of information to submit?
Well, it varies by party, but transactions I've been involved in, people are thinking about this early and starting to put material together, certainly in advance of a deal actually being signed. But you wouldn't want to put this kind of effort in until you had something, pretty close to done. And also you're going to need a lot of collaboration with the other party.
And do the states treat the submission as confidential in the same manner that the federal authorities do?
So most of them do have various confidentiality provisions applying to what's actually submitted, although some of them require the notices to actually be posted on websites and things like that. New York, for example, will publish a summary of the transaction along with details like the explanation of the groups likely to be affected, information about the services currently provided, any commitments to continue those services, and any services that will be reduced or eliminated. And the objective here, I think, is to get out to the public the information about what's going on and give them an opportunity and a forum in which to give their opinion, if necessary, complain about the transaction. And so to get a lot more views on the impact of the transaction that might just be coming from the parties. Usually the detailed reports coming out of some of these processes and the decisions will be made public. Parts might be redacted if there is confidential information. So, for example, some of these jurisdictions have a process called a cost and market impact review that they go into, which is a very in-depth analysis of what the impact of the transaction is going to be. And when that report is finished, that report will be made public, and the public will be given an opportunity to comment on it. So there, I think compared with the HSR process, there is a lot more information that's going to be out there about the deal and about the arguments that are being made on the deal than you would see at the federal agency side, where you really wouldn't find out what the government was thinking and what the parties were maybe saying until you saw a complaint and an answer in a challenge.
And then recognizing differences state to state, are there approval rights of these states for material change notices? Or if there is a issue, whether competition or otherwise, does the authority need to go to court to block the deal or seek interim relief?
Most of the state laws I've been looking at only have notice provisions. If the state, whichever agency is notified, and then usually it would be referred to the AG. If they have a concern about the transaction and they want to stop it, they would usually have to proceed through, Section 7 or under a state law that gives them the ability to challenge a transaction. There are, however, a few of these regimes that are suspensory. So there is some affirmative approval required. So, for example, in Colorado, I mentioned a particular type of review is when a nonprofit goes to a for-profit. There's an affirmative approval required in that situation. Hawaii has an approval requirement. They have 90 days to approve or disapprove. New Mexico has a 120-day notice and approval process. And Oregon has a 180-day notice and approval process. And it also has a stop-the-clock provision, which can give it even more time. Otherwise, though, most of the regimes, even though the notice periods can be fairly long, are just notification regimes. And technically, you could close over one of these reviews. If there were significant issues in your transaction, you might not want to.
And shifting gears back to private equity for a moment, and no need to take a position here, but the Biden administration's FTC was very focused on private equity's investment and control in healthcare. I'm wondering whether there is different criteria to assess a private equity transaction that is reported to a state, or whether there just may be greater suspicion, but using the same criteria that you set forth earlier.
Yeah, the Biden FTC in particular, as you say, focused very heavily on PE, and there were several public forums that the commission held where doctors, nurses, other healthcare professionals raised concerns about the impact of private equity ownership on health providers and healthcare facilities. And so, we saw in the USAP case, for example, the FTC going after not only the entity that was doing the roll-up, but also the PE owner who allegedly kind of masterminded that process. And with the change in administration, I think you've seen a kind of lightening of that focus. While they'll focus on roll-up transactions, they're not necessarily doing it from the perspective of PE is inherently suspicious. I do think the states, though, are following more on the Biden track. And maybe not without reason. They have experienced some really high-profile failures of entities that did have PE involvement. The Steward situation in particular, you had this real estate sale leaseback arrangement with all of the Steward assets, which, ostensibly is what really sent them into the free fall that led to the failure of Stewart. And so Massachusetts, which had these healthcare transaction notice provisions for a dozen years, broadened the rules so that a transaction involving a significant equity investor, which includes PE companies, and expressly involving sales or transfers of assets, including real estate sale leaseback arrangements, have to be notified. And so you see a direct response and an express response in the Massachusetts law to get at PE transactions. A couple of other states have also introduced this express PE provision. So, for example, in California, they revised their regulations in 2024 to expand the scope, pretty low thresholds, fair market value of 25 million or more, increasing the acquiring entities' California revenue by at least 10 million or 20%. And so this now applies to M&A between healthcare entities and involving PE firms and healthcare entities, and transactions where a non-healthcare entity is a counterparty to a transaction with a healthcare entity. So you can see there this continued focus on private equity investment and control in healthcare. And I think that we'll probably see more of the state healthcare notification regimes expand if they don't already pull in those kinds of deals.
So you've described how some of these laws are evolving where they already exist. Some other states, I gather, have some of this legislation still under consideration. What else is on the horizon? Are we looking at eventually a 50-state patchwork?
Well, certainly right now we've got a 50-state patchwork. I think the big takeaway right now, though, is these laws aren't just healthcare. I think at the outset I mentioned that, they were starting to expand beyond healthcare provider deals, and we have some states that introduce some specific regimes for like PBMs in Massachusetts, pharmacies in California. But more recently, there is this model law that's been put out by the Uniform Law Commission, which, if it's adopted by a state, would require an HSR filing, if you're filing an HSR filing, to submit that HSR filing to the state. Right now, only Washington State has enacted the law, but it's already been introduced in the legislatures in California, Colorado, DC, Hawaii, Nevada, Utah, and West Virginia. And as things develop, other states may jump on the bandwagon there. That one's an interesting one because it's relatively limited in requiring just the HSR form to be submitted to the AG, which is something that probably would happen if an HSR was filed and then an AG took an interest in a transaction, and then they would seek a waiver and they would get the HSR materials. But this puts in place an obligation to do it simultaneously, in a way that I think when they changed the HSR form, they put a checkbox for an advance waiver to share the HSR with states. And I don't think anyone's checking it, although Gwendolyn Cooley will hate me for saying this, but I don't know anyone who has checked that box. So the Uniform Law Commission proposal does kind of address that issue and gives the state the ability to get the HSR early. More generally, on all of these different state notifications, there are just so many amendments and expansions and new notifications being introduced all the time that it's really hard to keep track of it. And we're kind of in a similar situation to where we were with data privacy and things like that, several years ago, and may still be. That's not my area, but I know that, every state has its own take on these things. So they're going broader than healthcare, and they're going lower thresholds than HSR. We've got a bill in New York at the moment that would shift the law from, on a general merger notification, a notice only to a pre-closing preliminary review, cost and market review, just very expansive kind of requirements. And so I think you've got to keep an eye on those things and see how they're going to affect your transaction. I mean, at some point, we're going to have a multi-jurisdictional matrix for the states.
As the laws continue to evolve, it'll be interesting to see just how busy the state AGs get in this area. Thank you so much, Lisl, for a fascinating conversation. For those of you who want to learn more about this, we'll be posting a link to the model statute that Lisl discussed on the episode webpage. This is definitely a hot topic for now and in the future. Now, Lisl, before we let you go, we have a couple of ending segments that we do on every episode of our Curious Amalgam. And the first thing we want to do is get to know you a little bit better as a person. So we want to ask you this. Is there anything interesting or unusual about yourself that is completely outside of your professional life?
So maybe the most interesting thing about me outside my professional life is that I love to sail. I love the water. And over the last several years, I've been getting more interested in offshore racing. So I've done the Newport Bermuda race a couple of times now. And this year I'm hoping to race from Annapolis to Newport on a friend's boat with a crew of 10 people, which is a lot of fun. You know, it's quite amazing. You know, you leave these races with, 100, 200 boats, and you kind of see all of the boats at the start. 2 days out, you're looking around and you do not see a boat on the horizon, and no land, of course, either. It's just an amazing feeling of aloneness out there. And sometimes you see some great sea life too. I've seen whales and dolphins and flying fish that jump up and land on the deck, which is kind of interesting. And then as you get to the finish, hopefully, if you're kind of abreast with your competitors, you start to see them popping up on the horizon, a day or so out, and then you all converge on the finish line.
Wow, what an experience. Now, the last thing we do is play a little game that we call the Curious Hat.
And now it's time for the Curious Hat!
The rules of the game could not be more simple. Rubin is going to pull a surprise question out of the virtual hat. And take it away, Rubin.
The hat must have been listening. Lisl, what is your favorite state that you've been to and why?
Is this like Miss Congeniality, where I talk about my favorite date, which is 26th of July? No, sorry. My favorite state and why? I would have to say New York State, which is where I live. And why? Because it runs the gamut from big metropolis city where you can go see a show, to upstate apple picking, to sailing on Cayuga Lake in Ithaca, or sailing on the Sound. It's a place where you can do everything. It even snows here. I'm from Australia, so I've always really enjoyed being in places where the trees change color and you get snow in the wintertime.
Well, great selection. The New York State Board of Tourism thanks you for your service. And we thank you, Lisl, for being a great guest. And thank you, Rubin, for being a great co-host. Thank you, listeners. Tune in for next week's Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.